All right, it looks like that witness, Elva Francesca, is done with her testimony as it appears right now. Andrew Cherkasky, is a trial attorney out in Los Angeles. He's joining me now. Andrew, good afternoon for you, sir. Good morning to you out in California.
Good morning.
So let's dive into this. We saw this former employee there on the stand talking about some invoices that were going back and forth between Merritt and McStay. Now, of course, the prosecution, again, it says this entire thing has been about money. But this is a former employee of Charles Merritt. Do you really think that she would be heavily involved in the back and forth between McStay and Merritt and what their agreement was? How does the prosecution expect her to know any of these intricate details?
Well, I don't know that it's so much about necessarily knowing all of the intricate details as much as it's starting to lay out as much as possible in a case that's very detailed, as much of the information about the financial history of these two as possible. The problem for the prosecution is the money, the dollar amount, isn't that significant. So they've got to do everything they can to show that financial connection.
Yeah, you're right. It is not that significant, at least to go from the money portion to killing 4 people and then transporting them 60 miles to the desert, digging 2 graves, and disposing of their bodies. And again, now, we didn't see a lot of evidence inside that home of a crime. Now, yesterday we heard testimony from the medical examiner during cross who said, yeah, based on the injuries, there should be some amount of blood inside that home, but we didn't see that there. So, again, I still think the prosecution has an uphill battle, not only proving motive at this point, but proving something happened in that house and that Charles Merritt was the individual that killed 4 people. What say you?
The idea of a motive isn't necessary to prove a crime occurred, and that's something that the prosecution in this case needs to be very aware of, and I'm sure they are. Juries love it, though. Juries want to know why somebody did something. If they're the ones who the prosecution's pointing the finger at, it's answering that question why. So it's an interesting issue that under the law, there's no need to prove motive, but common sense, the jury wants to hear it.
Right. Now, it appears there's a police officer that has just taken the stand in the Charles Merritt trial. Let's go to that courtroom right now. All right, we're still hearing testimony from that former investigator. Still with me, Andrew Cherkasky. Andrew, I want to talk about this here. Now, this search warrant that was conducted in August of 2014 was 9 months after the McStay family was found. You heard the testimony that another family had actually moved in, and you heard the defense saying, what was the point of going back? You know, San Bernardino had done a search warrant way back when the family went missing. So, I have to agree. What did he think he was going to find there when a family has moved in? They've painted walls. You know, it's their furniture now versus the McStay family. What was the true point of this search warrant?
I'm not sure what was going through their minds. As a former prosecutor, I can tell you that I want to make sure that every angle that the defense can go down is shored up. Could the defense have made a point that, oh, well, you didn't go back and take a look at the house, you didn't do a thorough enough search, and that's somehow poking a hole? Perhaps. I don't think that it was a particularly effective police move in this case to go back and search again 4 years later.
Yeah, I couldn't agree more. I mean, I don't know what they thought they would find there. I'm sure the family that purchased the home, that moved in, they knew the circumstances of that home, hence painting the walls. I'm sure the house got a thorough cleaning before they moved into that house. So I just don't know what they were going to find there. So do you think that this could come back, against the prosecution to say, you guys still aren't proving your case here. You guys are you're tap dancing around a whole bunch of stuff that you're trying to make up?
The biggest problem for the prosecution in this case is that they lack a narrative about what happened. They lack evidence to establish what even a theoretical narrative is about what happened. Where was the family captured? Where were they murdered? How were they brought to a different site? That narrative isn't something that the evidence in this case strongly supports one way or the other, and the failure to find something at that home just adds to that pile of inability to establish the narrative.
Yeah, and if you can't establish the narrative, we know how juries are. They could go in a way the prosecution doesn't want them to go. I understand the Charles Merritt courtroom just went on morning break, but we'll have more to come of that when it goes back live. Stay tuned to the Law and Crime Network. We're going to take a quick break and get right back to the Charles Merritt murder trial. Stay tuned. We want to switch gears and talk about the Charles Merritt case. Now, of course, the prosecution has many theories in this, that the family was killed inside the home, that Summer was actually sexually assaulted before her death. Now, we heard testimony from the medical examiner of how the bodies were actually recovered from the grave site. So let's hear more of her previous testimony from the medical examiner right now.
Now, could an injury like this occur without there being any actual blood that comes out on the outside of the skin?
Yes.
How could that occur?
Because you will have blood coming out of the skin if there was a laceration, an open wound. With a trauma like this, you're definitely going to have external injuries, but it could be a bruise or an abrasion. It doesn't have to be a laceration.
How about some of the other fractures that we looked at with respect to Summer McStay? Is it possible for those injuries to have occurred without external lacerations?
Based on the number of pieces of skull that are broken, you would expect that there would be some lacerations, but not all of the skull fractures need to have an overlying laceration.
So is it possible that you could incapacitate somebody to a certain degree, because you can't tell us how many of these fractures occurred at one time? Is it possible you could incapacitate somebody to a certain degree without causing a laceration to the skull with blunt force trauma? Medical evidence that you observed that could tell you if she was raped?
No.
What type of evidence would you need actually to determine whether or not a rape had occurred in terms of tissue?
In terms of tissue, you want to see that there's trauma to the soft tissue of the vaginal area.
And because there was no tissue attached, you cannot make any medical determination that that occurred. Is that correct?
Correct.
Were you able to determine the cause of death?
Yes.
What was that?
Multiple blunt force injuries to the head.
And were you able to determine the manner of death?
Yeah.
All right, so I don't think there's any debate here what the cause of death for the McStay family was. Blunt force trauma based on the injuries. Now, you heard testimony there from the medical examiner who said maybe not necessarily it would have caused a lot of blood as many people would think. But one thing she did touch on, Andrew, I want to talk about was, again, the prosecution says that Summer was sexually assaulted. But, of course, if you're not able to take a rape kit, you cannot prove sexual assault. And in this case, there was no tissue to actually test for semen or things of that nature to suggest a rape case. Rape had occurred, or sexual assault, I should say. So, again, from a prosecution standpoint, I think their narrative is kind of going downhill based on what we see in the physical evidence. What say you?
They seem to be overpromising on one thing after another that they don't need to necessarily prove. The idea of establishing that a rape took place this many years after the crime happened with no tissue, no DNA, no signs of trauma to that area of the body that's particularly unique given the circumstances, it's just not something that they're going to have any real ability to do. They're just trying to be salacious.
I do want to clear something up. I said the prosecution, but it was actually an investigator who said that Summer was sexually assaulted here. But again, there's no, from what the medical examiner testified to, there's no evidence of said sexual assault. Now, we do know that Joseph was actually found with some type of cord around his neck. So let's take a listen to Detective Edward Bachman about how Joseph McStay was found.
So up here would be the victim's head. The hole that I described would be right here, where there was obviously wounds to his head. You can see here his back continues down. These are the victim's ribs. As we continued uncovering it, we located a white extension cord that was wrapped around the victim's neck that continued south through the grave. The way that the victim's laid out in the grave, his legs continue down here. So at this stage, you can see part of the bottom of the victim's legs here, but there were no skeletal remains located below the kneecaps inside the grave, or below the knees.
As the excavation continued, please describe what you were seeing.
So as it continued, like I said, we located the white extension cord. The extension cord was found to be tied in a knot around the victim's neck, and it continued south through the grave. It was found that the victim was wrapped in the white blanket that we initially saw, what we believe to be a white blanket, a white woven cloth of some sort, and the cloth was wrapped with a red tie-down, like a tie-down type strap.
All right, previous testimony from Detective Bachman about how Joseph McStay was found. Andrew, I want to touch on something here that I'm having a hard time with, right? So we know that there were 2 shallow graves not too far from the main road, I believe maybe a quarter mile from the main road. And we know how long it takes to actually dig shallow graves. You can see that there on your screen. This is something, if one person did this, it would take a considerable amount of time. You would have to then move the bodies into those graves, then cover the bodies back up. With that being so close to the road, do you think that even for, let's play devil's advocate, even if Charles Merritt is involved in this, do you think that he alone could have dug those graves without worrying about people passing by or a motorcycle coming across? That's who found the bodies. That's a lot of work for one person to do. What say you?
I've always wondered about the possibility of an additional assailant of some sort, because even if you look at the idea of luring the family out, whether they were conscious and went on their own, or whether they went in, and either murdered them there or somehow injured them at the home. A family of 4 is difficult to manage with one assailant. So I can see it either by looking at the fact that somehow they were lured to the location and the fact that we've got 2 shallow graves. You're right. It is something that points to the possibility that at least two people were responsible.
Yeah, absolutely. And I have to touch on something. We've heard this name before, Dan Kavanaugh. And if you look at some emails between Joseph and Dan, their relationship was kind of heated. I mean, I want to read one of the quotes here where Kavanaugh had told the McStay family, McStay had told Kavanaugh, like, now Summer and I and the kids know who you really are, the potential to harm me and my family. And he actually comes back, Dan Kavanaugh, and says, well, since you know, you should make better decisions. So, again, I don't think we can overlook Dan Kavanaugh, especially given the fact that, hey, these bodies were so close to the road, and I personally believe 2 people would have had to have done that.
So I think that you're making a great point that if the prosecutors take time to watch our conversation, they need to start to focus in on. The fact that we can sit here and talk about these very real questions are things that are going to enter the minds of the jury. They want to know the full story, getting back to that idea of the narrative. And the narrative that you and I are seeing here is that it doesn't appear that just one person could have done all of this, given some of the different theories of how this all went down. So they better start answering some of those questions that even you and I have.
Yeah, and let's not forget that Dan Kavanaugh's girlfriend claims that he actually confessed to her about the murder. So let's hear more testimony from Detective Bachman right now.
Describe what you're seeing, or what you recognize.
The photo here basically is at toward the completion of the excavation process. Basically, the way that we excavated is we tried to basically pedestal the victim there in the ground so that we could see the way that he was laid out inside the grave. As I spoke earlier, you can see here's the red strap that is wrapped around the cloth blanket. So part of the blanket was able to be removed, but it was very brittle due to the fact it was soaked in decomposition fluids. There's the white strap that actually goes up, and it was wrapped around the victim's neck. The victim was clothed in a green shirt. Part of the green shirt was located there. He had on gray cloth shorts, and then a set of what were labeled gray Hanes underwear.
You mentioned in there that no leg segments were found below the kneecap. Is that demonstrated by what you're seeing in this exhibit?
Yes, sir. So basically what would be the femoral condyles, what was described to me as through one of the academic through Dr. Gray, basically extends right here, but there were no lower portions of the decedent's legs located inside the grave.
Did you find anything that appeared to be feet?
No, sir.
or at least readily recognizable as feet?
No. After we removed the victim from the grave, we located a pair of socks underneath the victim's body, but there was nothing of any indication of lower legs or feet there inside the grave.
Is there a compass depicted in 212 also to...
Okay, still looking at photos of the grave recovery site of the McStay family, and that was the body of Joseph McStay that Detective Bachman was talking about. Andrew, I want to touch on something here because this, I guess you could consider, was a cold case. They went missing in 2010. Their bodies were recovered 3 years later. So you know with cold cases, especially when bodies are in the elements, things like DNA, anything that could be crucial to finding out who did this, they just get wiped away. You have rain, you have wind, you have all of these factors that washes that type of evidence away, even tire tracks, footprints, things of that nature. So how big of a hurdle is that for the prosecution in this case? Because you're really not going to have that there when the bodies were found 3 years later.
Well, you're talking about forensic evidence, and forensic evidence absolutely starts to denigrate as time goes by. Also, eyewitness testimony, the people who know about what happened close in time. So any time that time passes and you don't have that proximity to the actual crime itself, that starts to be negative points that go against the government and tend to go for the defense. So it leaves questions on the table. And unfortunately, that's something that's very difficult for prosecution.
Yeah, and you made a good point. You said time. So we're assuming that the last time Joseph McStay was seen alive is the day they were killed. But in theory, we really don't know that because, I mean, maybe they were held captive for a while. Maybe they did go on a vacation and came back and then something happened. We really don't know when the actual time of death was. We don't know when the crime was. So I think, again, that's a huge possibility that the prosecution has to come up with to say, we know it happened on this date. We know it happened this way, and this is the person that did it. We're going to take a quick break. We're waiting for the Charles Merritt courtroom to go back live. We'll have more of that live coverage as soon as it goes back. Stay tuned to the Law&Crime Network. All right, so that was the defense, and Andrew, I got to tell you, he does make a pretty compelling case here. I listened to the police interrogation of Charles Merritt, and he did talk about how he told Michael we needed to call police. He told Susan Blake that they needed to call police, and they each said, wait, maybe he's on vacation, he'll be back. So do you say here that, oh, he was trying to insert himself in the investigation and throw them off, or was he really concerned with the well-being of the McStay family? What say you?
Prosecutors love consciousness of guilt. It's something that in every case they focus in on. Whatever evidence they can find that a defendant had some sort of consciousness of their guilt, that they were avoiding the police, that they were missing at a certain critical time, they focus in on that. As a defense counsel, consciousness of innocence is critical. And in this case, they've got a lot of evidence of it.
Yeah, they got a ton of evidence. Again, I mean, here was Charles Merritt telling police that, well, I told the family that you needed to contact police. They needed to contact police. And, you know, they, for whatever reason, did not do that. So, you know, how do you now say that I killed the guy I was actually trying to find? And by the way, not only did I kill him, I killed 3 other people, and I moved their bodies without a trace, without anyone seeing me do that. Because to this day, I don't believe we've had a witness that said, hey, I saw a guy that fit the description of Charles Merritt carrying out what appeared to be bodies from the home, and then at the gravesite, someone passing by, hey, there was a truck here and this guy was moving stuff and I saw him digging holes. So we don't have that yet. And again, from the defense standpoint, here's the guy that's telling everyone to call the police.
Right. We've got some evidence of a vehicle with security camera that maybe matches a vehicle that's similar. We've got the cell phone tower pings near the gravesite. That's important evidence for the prosecution. But they are missing that kind of eyewitness testimony that puts the individual in the home or the individual at the gravesite that we would expect if it was closer in time we might be able to see.
Yeah, and the thing about video surveillance, it's not, especially when it's dark and it's grainy, you can't say with 100% certainty that that was Charles Merritt's truck. The cell phone data, of course, can be challenged by a defense expert, if you will, to say that maybe it was bouncing off a tower, maybe it wasn't. You know, we've seen that in other trials where cell phone data wasn't always as accurate. We are going to take a quick break. We're hoping that courtroom goes back live. Actually, I believe it is live. We'll have more of that live testimony from the investigator there in the case when we return. Again, Charles Merritt on trial for the murder of the entire McStay family out in California, who went missing in 2010. Their bodies were found in 2013. Stay tuned to the Law&Crime Network. We have so much more to come. We'll be right back. All right, so that's cross-examination from former investigator Joseph Steers in this case. Still with me, Andrew. Andrew, I want to talk about this. We heard that testimony there where the previous homeowner, or the current homeowner, I should say, rather, saw a stain that troubled her, but she didn't know if it was blood. And we heard the defense say, so you were concerned that the police back in 2013 did not find evidence of a crime, so that's why you went back. So again, I'm stuck on what was the point of this search warrant here that was filed 9 months after the bodies were found.
Well, a defense counsel loves to do their job by talking about what the police didn't find, and where you have two opportunities to talk about what the police didn't find, both through the first search and the second search, that's like defense counseling 101. Yeah,
absolutely. All right, let's get back to his testimony right now. All right, so that's testimony again from former investigator Joseph Steers. He's conducted a search warrant of the former McStay home, and I say former because after the bodies were discovered, new owners had moved into that home and, of course, did some painting, some rearranging, brought in their new furniture, and we heard the defense say, well, you were concerned with the fact that San Diego didn't find any evidence of a crime inside that home, and that's why you went back to do that search warrant. Andrew, I got to bring it up. I wonder how the jury is actually listening to this testimony and taking this testimony in that, hey, not only in 2013 did people say, oh, there's nothing really here, but now after the bodies were found 9 months later, this guy's going in with this search warrant and really finding nothing other than the new owner saying, well, there was a stain that appeared to be blood that she was troubled with, but she didn't know if it was blood.
I think the jury's probably reacting very similar to we are. What's the difference here? What was the point? What are we finding? Is there anything that helps suggest that a crime took place there? And the answer to all of that is no. I don't think that the jury's going to look at a possible blood stain and put any connection to this case, absent some sort of DNA, absent some sort of direct evidence of how it fits into the narrative. So this isn't particularly helpful to the prosecution, but it is important to tell the full story.
Yeah, I mean, that blood stain, or what she said troubled her, could have been a blood stain from, say, a painter who came in once they were renovating the home and getting it ready for the new owners. We don't know. Let me ask this. Do you think that maybe the prosecution should, I don't know if it's too late at this point, maybe change their narrative of this case and where these crimes actually occurred? Do you think they should come out and say, well, we don't know where it occurred, but we know this is the defendant. We know we have the right person?
I always think that it's best for a prosecutor to be brutally honest with the jury and not try to oversell their case. I think that the prosecution in this case oversold it a bit in trying to come up with a narrative, or at least trying to connect the house to the crime scene, and that they just don't have that. It's the cell phone that's their best evidence.
Yeah, and I think they should be expanding on that, but they're not quite there yet. We're going to take a quick break, have more live testimony in the Charles Merritt murder trial out in California. Right on the other side of this break, stay tuned to the Law&Crime Network. We'll be right back. All right, it looks like Joseph Steers is about to read from a report that he had there during his search warrant. Still with me, Andrew. I want to talk about the significance of reading that report to the courtroom there, because, of course, you can listen to his testimony, but it all depends on what he wrote during that search warrant. That's really the key here.
Sure. Anytime you've got the investigator reading a report, there's certain evidentiary strategic reasons to do that. You want to essentially have him talking about his observations nearer in time to his police work. It can be a reason, some sort of evidentiary requirement of the court. There's all sorts of different reasons to do that, but it does place him closer in time to his actual investigation.
Absolutely, and I think you can also challenge his testimony to say, well, you said this in your report back in 2014. Let's get back to his live testimony right now. All right, Joseph Steers, former investigator, still getting cross-examined by the defense. Andrew, we saw it got heated there for a few minutes during that testimony. The prosecution was objecting to everything, and you heard the defense say, Your Honor, I'm going to ask that the prosecution does not object to every question. But from a legal standpoint, can't the prosecution do that?
Oh, absolutely, and you need to. I mean, that's critical to what lawyering is all about. If any of your viewers who have been watching this trial day in and day out know, things have gotten quite heated outside of the jury's presence. The prosecution and the defense counsel in this case do not seem to be making very close friends here.
Yeah, I don't think they're going to be invited to each other's Christmas party, if you will, or each other's wedding or whatever. So they're definitely not making the best of friends. But, you know, this is a serious case here. This is a death penalty case. 4 victims were killed. The prosecution said it happened inside the home, and the motive was money. And Charles Merritt is the person that did that. And, of course, the defense's job is to say, nope, this is not the guy. So, of course, this is going to be very heated back and forth between both sides. We are going to take a quick break. We have so much more live testimony to come in the Charles Merritt murder trial. You don't want to miss it. Stay tuned to the Law and Crime Network. All right, looks like there's a sidebar going on in that courtroom. Andrew, I want to touch on what we heard during the break, that when the defense asked, hey, is there any evidence, did you find any evidence that a crime occurred in this home? At the end of the day, he had to say no. I think that was pretty huge. What about you?
I think so. I think it's what everybody in the courtroom already knows. They don't have the blood. They don't have the DNA. They don't have the spattering that you see in some of these cases. He had to say no. So as much as it's helpful to the defense, as we've all been talking about, it's also helpful to this detective to maintain his credibility to answer that question honestly.
Yeah, so what do you think when he was trying to say in the totality and based on his experience? Because experience is one thing, but cold, hard evidence is an entirely different thing.
Sure. I think what he could also have said is, in my guess, is that it occurred there. He's guessing. He's putting things together. He's trying to figure out, okay, how could these bodies have been moved? How could this have happened? He's trying to answer the questions that the jury needs to answer by answering that question.
Right. It looks like the prosecution is starting redirect. Let's get back to the courtroom. All right, so that was redirect from the prosecution. It looks like a sidebar is going on in that courtroom. I want to bring my guest back on, Andrew. We heard that bombshell that there was no evidence found inside that home. As much as the prosecution or the investigator in this case wants to give his professional opinion, I think a jury leans more towards evidence because that's what juries want to see. They want to see that, yes, there was evidence of a crime that went on in this house.
In a case of this complexity, the jury absolutely wants to see that. And I don't think they give a whole lot of weight to a detective that says, I think X, Y, and Z happened. Because really what the detective is doing is he's creating a theory so that he can go out and look for that evidence. He created that theory so that he can then go find the blood. It's not to then introduce it to the jury to somehow convince them that it happened that way when he didn't come up with any evidence.
Right. And I'm glad you used that word theory because a lot of times, especially in cold cases, that's the only thing investigators have to go on is a theory. They don't have eyewitness testimony. They don't have blood spatter. They don't have the things you would need to say this is what happened inside that home back in 2010. So the word theory here is perfect, Andrew. I'm glad you said that.
Yeah, it really is something that detectives who are very skilled at their job can do well. They can come up with a theory. Here are the factors that I have. Why don't I go talk to this bar the people at this bar that I know he goes to? Or let's go look at the fishing hole that he often frequents. And they go out there and they start digging around and they find evidence. That theory brought them to the evidence. It's not the theory that gets the guy convicted. It's the evidence that gets the guy convicted.
Yeah, and they didn't talk to people at the local bar or anything like that. I mean, the person they talked to since day one was actually the defendant in this case, who again said that he told the family they needed to contact the police. We're going to take a quick break. There's so much more to come in the Charles Merritt murder trial. Again, he's on trial for the deaths of the McStay family, who went missing in 2010 and their bodies were found in 2013. More of that live testimony on the other side of this break. Stay tuned to the Law&Crime Network. All right, again, that's Diana Wright. She's an FBI forensic expert. Now, we heard the testimony there that she was called in to analyze some paint chips found in the McStay home. Still with me, Andrew. Andrew, I want to talk about the significance of these paint chips. We don't know how this testimony is going to go, but I assume that the prosecution is trying to paint some kind of evidence against the defendant in this case, Charles Merritt.
Juries love the forensic experts, so to get an expert on the stand to draw connections, that's critical for the prosecution. I don't expect this to be any sort of groundbreaking evidence or any sort of evidence that directly places Mr. Merritt as the assailant, but it's something that I think will be helpful to the prosecution.
All right, let's hear more of Diane Wright's testimony. Okay, we're hearing testimony from FBI forensic expert Dana Wright. She's talking about some paint samples, especially as it relates to the home and to a sledgehammer that is believed to be the murder weapon. Andrew, I want to talk about this testimony. Right now, this testimony is just starting out. Jurors may be nodding off, or they may be pretty interested in this testimony because this case will boil down to forensics. Forget the theories, forget the narrative. It will boil down to forensics.
I think that's correct in a lot of regards in this case, because there isn't some sort of smoking gun with regard to a confession or with regard to an eyewitness. So we have forensic testimony coming in now. This is an extremely complicated area of chemical analysis, the fame that she's talking about. I've dealt with that many times in forensic cases. So she's going to go through this process. I haven't seen her report. I'm excited to hear more about what she has to say.
Yeah, absolutely. I mean, I think this testimony is very crucial. Anytime you have a forensic expert, especially from the FBI, you're not talking San Diego police, you're not talking about any local law enforcement. This is the law enforcement of law enforcement. It's the FBI, and people actually listen to that testimony from FBI experts. So I'm curious to see how this testimony will go. Andrew, I know you have to go, but someone that you know very well will be joining us here soon. So Andrew Cherkasky, I think I got it right this time. I want to thank you so much for joining us here on the Law&Crime Network, sir.
Thank you.
All right, we appreciate it. Again, we're having live testimony right now from Dana Wright, an FBI forensic expert in the Charles Merritt murder trial. She's testifying about some paint chips inside the home and on the sledgehammer, which is believed to be the murder weapon. We'll have more of her testimony live on the other side of this break. Stay tuned to the Law&Crime Network. We'll be right back.